David Cleandon.
Speaker, and I'm pleased to take a call on this bill, and in doing so I just acknowledge my colleague Keith Locke, who has led your charge and done the background work on this piece of proposed legislation. In the first reading of this bill we did support it to Select Committee, but alongside it was qualified support, and in the first reading speech my colleague made he posed two challenges, if you like, to the mover of the bill. He said that whether we support it beyond the Select Committee, beyond the first reading, would depend on whether it proved in the Select Committee that there is a real need for this bill. And secondly, are there ways to handle some of the downsides of the bill that were spoken about at that point? And in summary then, he posed the question, what is the problem that exists that requires the intervention of this bill? Clearly, it is often said that we are over-legislated, that we have too many laws, too much legislation. And we've come to the view that this bill is simply unnecessary. It would serve no useful purpose, and there are some definite negative elements to it, which would do nothing for industrial relations, for employment relations in this country. We have done the work, we've done the investigation, and we believe that there is no demonstrated pattern of unions engaging in strike action without a democratic mandate from their members. Any strike or any proposed strike that came without the support of the members of a particular union clearly would not win their support and potentially would lead to loss of membership of the union. Indeed, unions are legally established as incorporated societies and as such are obliged to operate in a genuinely open, transparent, democratic fashion. And to impose any sort of strike action on their members could clearly be seen to contravene that and could lead ultimately to the dissolution of a union. Clearly there is no case to be made for the imposition of these rules, of this legislation. It's bad law to make it, any law that intrudes unnecessarily on the functioning of voluntary associations is bad law, and this is what would be established if this bill were to pass into law. One of the aims of the Employment Relations Act in Section 3, and I quote, is reducing the need for judicial intervention. And clearly we believe that this bill, if it becomes an act, is likely to lead to more legal challenges. It will create situations where employers could potentially use these provisions to challenge and to delay and to harass unions who, for quite legitimate and decent reasons, were proposing strike action. The point's already been made that there is no countervailing requirement, for example, that the shareholders of a publicly listed company be obliged to conduct a vote and get a democratic majority position to impose a lockout on workers. And one wonders why you would go down the path of imposing extra constraints on employees but not on employers. Thirdly, the application of this law will be impractical, and the Unite Union made a very useful contribution, pointing out that a union membership that is dispersed, consisting largely of younger, particularly transient members who are dispersed geographically around the country, it would be extremely difficult practically for such a union to hold a democratic vote to test the waters amongst their members. There are issues, considerations about health and safety, and yes, the bill at least purports to prevent health and safety issues from being to prevent employers from preventing a strike on health and safety issues. I recall many years ago an instance where a group of men went on strike because when they came to their break there was no hot food available to them, and there was something of a public outcry at what appeared to be quite a petty reason for strike action. But in fact those men were doing hard physical work in a very cold environment. Wouldn't that instance, that example, be an interesting test of health and safety issues as we understand them now? Clearly this piece of legislation would create the opportunity for legislative mischief, for unreasonable and unsustained challenges to the legal right of workers to withhold their labour when they deem that is the last resort to them to achieve decent relationship, decent salary, wages, conditions, whatever it might be. It boils down to a simple fact. This law is unnecessary. It would impose costs. It would impose burdens unfairly, unreasonably, and the Greens will oppose it. Kia ora.
Rahui Katini.
Thank you, Mr Speaker.